Hi there, this is Jonathan Ginsberg, and today I'd like to talk to you about reaffirmation agreements in Chapter 7 bankruptcy. Now, you may have read about reaffirmation agreements before, and you know, if you have, that when you reaffirm a debt, and typically this is going to be a secured debt like a mortgage payment or a car payment or possibly a furniture or jewelry loan, what you're essentially doing is saying, I want to keep that collateral, I want to keep that property, and I want to basically take this out of bankruptcy and continue to make payments as if I'd never filed. And basically the reason you would file a reaffirmation or sign a reaffirmation is that you want to keep your property and you want to give the lender some assurance that you're going to make payments. Because when you reaffirm a debt, you are again assuming personal responsibility, personal liability for that debt. If you do not reaffirm the debt, and let's take for example a car, if you don't reaffirm your car loan, you are no longer personally obligated on that car, although the lender still has a lien against the property, but you have no personal liability. Some lenders will not agree to let you keep the vehicle without the personal liability, without the personal agreement to pay. And for some people, even more importantly, if you do not reaffirm your debt, your payment history, a positive payment history that you make in months and years to come, will not show up on your credit. So if you do not reaffirm a debt, you keep the collateral, continue to pay, they call it keep and pay or stay and pay sometimes, you will be able to keep your collateral, keep your house, your car, furniture, and so forth. But when your credit is pulled, those payments that you made, painstaking payments you made over the years, will not show up on your credit report. And for a lot of people, rebuilding their credit is very important, and so they want to reaffirm certain debts to rehabilitate and rebuild their credit. If you don't reaffirm, you can't do that. However, the way reaffirmations work now, it's not like it used to be where you basically sign a one-page document and you reaffirm and everybody goes on down the road. Now reaffirmation agreements are 8 or 10 pages, and they include in it a declaration by me as your attorney that I've looked at this reaffirmation and it's in your best interest. And that reaffirmation with that declaration and a lot of information about your budget and so forth has to be presented to the bankruptcy judge, and he's got to sign off on it. And here's where sometimes a problem exists. Number one is that when we do a reaffirmation agreement, we have to show that you have some money available in your budget to pay the debt. So in other words, if you have a car payment of $350, that $350 must be reflected in your budget, that we've accounted for it, and also we have to show that your budget is not negative. In other words, if you are not working, for example, have no money coming in, and your budget is negative $2,300, we cannot reaffirm the debt because your budget on its face does not show there's enough money to pay your car note along with everything else. So one of the things in a reaffirmation is a declaration, or we have to reveal that you have enough money in your budget to pay your regular expenses plus whatever else you're reaffirming. If you have a negative budget, there is a presumption that that reaffirmation is not feasible, and the judge will not sign off on it. He will actually request and insist that you appear at a hearing to explain why you might be able to make those payments. And it's really hard if you have negative numbers in your budget. And even more importantly, from my end, is if I sign off on a reaffirmation agreement, I'm basically asserting that I've looked at your budget, I've discussed the reaffirmation with you, and that I feel that you have the wherewithal, enough money in your budget to make your reaffirmation agreement payments. If you have a negative budget, I'm not going to be able to do that, and I'm not willing to do it because, in theory, if I sign off on a reaffirmation agreement, you are not successful down the road, you could pursue me for liability that I gave you bad advice. So reaffirmations are no longer just a pro forma exercise in signing a bunch of documents. Instead, they reflect a concerted review by you and by me as your attorney that you can afford to keep this particular collateral. And there are some cases where I have told my clients I cannot sign this reaffirmation agreement. For example, I recently had a case where my client had a home that was, let's say, was valued at $200,000. He had a first mortgage of $190,000 and a second mortgage of $50,000. So basically, he had $240,000 of debt on a house worth $200,000. In addition, his budget was such that we had to really squeeze to fit the 2 mortgage payments into that budget. Basically, when we looked at his budget, there was really not enough money to pay for necessities like food and electricity and so forth, because we had to squeeze both mortgage payments in. So when I looked at that as a whole, what I saw was, number one, we had negative equity. We had a house that was worth far less than what was owed on it, and probably would not be worth what was owed on it for many, many months or years. And secondly, we had a budget that was barely feasible, that if we looked at that budget carefully, it was probably not very likely that that person would be able to sustain payments, let's say for a family of 4 having $200 a month for food. It just wasn't going to work. So I told that client before we filed, I said, look, you know, I am not going to be able to reaffirm or sign off on a reaffirmation on this house. Now, you can do a stay and pay if the lender will agree to it, where you continue to make the payments, but you're absolved of personal liability. But I'm not going to sign off on a reaffirmation agreement, because I cannot in good faith say to that judge that I think that you're going to be able to make these payments. Your budget just does not work. So a reaffirmation is by no means an absolute, a guarantee. It's not something that's going to happen without some discussion and some thought, and you really should talk to me or talk to your lawyer about it, because quite frankly, if you're going to assume personal liability for a debt, again, and you're going to take it out of bankruptcy, basically, the last thing you want to do is to take on a debt you can't afford, because remember, when you reaffirm a debt, you are now personally liable. The bankruptcy will be over, and you cannot discharge it in bankruptcy. You can't file for another 8 years. You're stuck with that debt. It's in effect a permanent debt. And the last thing you want is to have a repossession or foreclosure with a big deficiency claim that you cannot discharge in bankruptcy, all because you wanted to keep something that you really cannot afford. I think as bankruptcy lawyers, we're also counselors at law, and one of the things that a good bankruptcy lawyer, I think, has to do is to have a reality session with his or her clients, because I want you to see this bankruptcy as a one-time thing in your life that's going to put you on the road to financial rehabilitation, not put you behind the 8 ball again in 6 or 8 months because of a car or a house or some other property that you have reaffirmed. It's difficult sometimes to think about giving up a house or a car, and I understand that, but my thought is, and I tell this to a lot of my clients, if you're talking to a bankruptcy lawyer, literally everything needs to be on the table. Everything needs to be discussed. And certainly if it's a piece of property or some sort of item, secured item that you cannot afford, I'm going to tell you the truth that you cannot afford it, and you really need to let it go. And sometimes I lose clients over that, but that's okay, because again, I want to do what's right for my clients. I think you know, I have an obligation to them and to myself to do the right thing. And I hope that if you're in that situation and that we have a discussion and you're open to the possibility that maybe you can't keep that item that you want to keep, maybe that means we have to delay until the end of the school year, for example, but ultimately what it means is that we need to make the right decision for you at this point in time with your particular financial situation. That's my job. I feel that's really important for me to do it, and that's what I think is appropriate and the responsible thing to do in my representation of you. So that's a little bit more about reaffirmation agreements, my thoughts about them. Again, this is Jonathan Ginsberg. I hope to hear from you soon. Thanks a lot.